Good afternoon on the East Coast. Happy Tuesday. You have joined FLSA and Wage and Hour Issues for Restaurants, which is a webinar put on by PilieroMazza, a business law firm serving government contractors and commercial businesses. We operate in Washington, D.C., the surrounding area, and all across the country. If you have any questions about this webinar or about any of the services PilieroMazza provides, please reach out to me. I am the presenter, Matt Feinberg. I'm a partner in the Litigation and Dispute Resolution Practice Group at PilieroMazza. I spend a lot of my time representing restaurants in various litigation, but historically it's been a lot of Fair Labor Standards Act litigation. There is a particular push in this country for plaintiffs' attorneys to file lawsuits against restaurants because the wage and hour requirements for restaurants are extremely difficult to follow and easy to make mistakes with. So I've seen a huge increase in litigation against restaurants and food and beverage companies, hospitality companies in general. So we wanted to put together this webinar to give you a little bit of a background on the Fair Labor Standards Act, to give you some tips and tricks for making the right classifications and following your requirements of the FLSA, and give some ideas for how to resolve issues when they arise, whether they be informal or formal complaints. If you have any questions during the webinar, please feel free to use the questions or chat function to the extent you can. If at any point you get kicked off of the webinar, or you lose audio, or you have any other technical difficulties, please reach out. We will do our best to get you back online or to solve any audio issues. If, again, you get kicked off at any time, or you are unable to get the code due to an audio problem, please reach out to us and we'll make sure that we get you everything that you need. I gave you a little bit of the background of PilieroMazza, the firm that I represent. I do want to let you know that this webinar in particular is not an attempt to give you specific legal advice for your situation. We're not creating an attorney-client relationship, and any information that I'm providing is based on general statements of the law. If you have specific questions, or you've joined this webinar because you have a specific event or complaint or lawsuit that's pending against you, please reach out to me. I'll be happy to answer questions on an as-needed basis that are specific to your situation, but please don't just rely on the information received during this webinar to make any legal decisions, as the facts will change from situation to situation. We want to make sure that you're getting the proper specifically tailored information to help with your specific situation. So a little bit of background. For those of you who don't have a lot of experience with it, the Fair Labor Standards Act, or the FLSA, is the federal law that establishes both minimum and overtime wage payment requirements throughout the entire nation. It also prevents retaliation against employees for certain employment complaints, and it offers specific regulations that affect the restaurant industry a little bit differently than other industries may be affected. In addition to the FLSA, there are in almost every state a state statute that sort of mimics the Fair Labor Standards Act, and in some counties, cities, or municipalities, you might have a local wage payment and collection law. These state and local laws establish different, very specific minimum and overtime wage requirements in addition to the federal standard, and some states implement specific regulations affecting the restaurant industry as well. I say at the bottom of this slide that restaurants generally must follow both, but it really applies across the board. If you're in hospitality and there may be a regulation, both state, local, federal, that applies to you, you need to make sure that you're complying with all of the appropriate statutes, not just, you can't pick and choose. So the first and main issue that I want to address is the biggest area of concern for restaurants and hospitality companies of late. And so throughout this webinar, you're going to see that I've plugged in some myths at the top of some of these slides. These are comments that companies Other lawyers and industry professionals have asked me about over the years, some more than others. And it's really important that you understand that some of the general thoughts that people have when you run a business or when you're involved in the hospitality industry is that some of the information you have is just not accurate. And so we want to make sure that we're correcting those myths and giving you the proper lay of the land. So the first myth I want to talk about is if I pay my employees a fixed salary, I don't have to pay them for overtime. And this is something that comes up a lot. There's an assumption throughout the country that if you're a salaried employee, you are what's called exempt from overtime. And if you're a non-salaried employee, you're non-exempt. That's actually not true. We're going to talk about that in a few minutes. And the second myth that affects hospitality and restaurant, food and beverage industry in particular is that managers never receive overtime. The assumption is that restaurant managers are always exempt employees. They don't have to receive overtime pay. And again, that's not necessarily true. So what actually matters in the classification of employees is a very fact-specific inquiry to determine whether an employee is exempt or non-exempt from the overtime requirements of the Fair Labor Standards Act. And in order to be an exempt employee, you have to satisfy two tests. The first is the job duties test. The second is the salary basis test. For each of your employees, you should be making an independent classification evaluation. Some of those are going to be very simple. Servers, bussers, food runners, back of house staff, typically cooks, people in salad station or garde-manger, dishwashers, they're all going to be non-exempt. They're performing a lot of manual labor. The question becomes much more difficult when we're talking about executive, manager, and professional level employees of the restaurant or the company, and you need to be doing an independent classification analysis for each of those individuals to ensure that you're complying with the FLSA. You also want to make sure that you're keeping a record of your classification analysis. One of the biggest hurdles that you can come to if in the unlikely or potentially likely event that a lawsuit is ever filed against your company under the FLSA, you want to be able to explain why you classified a certain person as exempt or non-exempt, and you want to be sure to keep that record for the entire duration of their employment. And finally, you want to be very careful with your independent contractor designations. Now, in the restaurant industry, you're very rarely going to have an independent contractor who works for you. However, there are restaurants that I worked in before I went to law school where there was an independent contractor who did some finance or accounting for the restaurant. There were some independent contractors who did some sales or marketing work for the restaurant, but they were still paid by the company as an individual. And so you want to be very careful about your independent contractor designations as well. That's another webinar for another day on the difference between an employee and an independent contractor. But for purposes of this webinar, you just want to make sure that you're keeping in the back of your mind whether you have any independent contractors and how you're treating them. So getting back to exempt versus non-exempt status, the first layer of analysis is the job duties test. For the vast majority of the employees in the country, those individuals are going to be considered non-exempt. And what that means is if they work more than 40 hours in a week, they need to be paid at a premium rate for all of those extra hours. And similar to most industries, most employees in the restaurant industry are going to be non-exempt. So when we get to the determination of whether managers and professional employees are exempt, you have to go through the job duties test, which is an analysis of generally three factors. There are some other factors that are not particularly relevant to the restaurant industry, but these are the three main factors you want to take a look at. First, they need to be employed in a bona fide executive, administrative, professional, or outside sales capacity. We're going to talk about the two most relevant ones, executive and administrative exemptions, in a couple of slides. And in addition to that, they need to be paid on a salary basis of at least $684 per week. That doesn't necessarily mean they need to be paid on a weekly basis. They could be paid every week. They could be paid every 2 weeks. They could be paid semi-monthly. But then the average needs to turn out to be no less than $684 a week. So when we talk about the exemptions that typically come up in the restaurant industry, we're talking about the executive exemption and the administrative exemption. For the executive exemption, the primary duty of the employee must be management of a customarily recognized department or division of the company. They must supervise and direct the work of 2 or more full-time employees or their equivalent, and they must have the authority to hire and fire employees, or if there's another person who has authority over them, their recommendations must be given particular weight. Now, typically, you will see an exempt position in a restaurant, say as the kitchen manager, maybe a front of house manager, because the kitchen manager is supervising the entire kitchen staff. In a restaurant, the kitchen or the back of house is a customarily recognized department or division of the company. But what about a beverage manager? They may be a senior bartender or a key employee who's given the beverage manager title, but they don't necessarily have anyone that they oversee. That person would not be exempt even though you've given them a manager title, because if they don't have supervisory authority over at least 2 full-time employees or their equivalent, that they don't have the authority to hire and fire employees, then they don't meet the executive exemption. The other example I wanted to point out is the hybrid employee example. And this goes back 20 years to my days as a server and a bartender. But the restaurant that I worked in only had didn't have enough managers to cover all of the shifts. And so what they would do is ask certain very senior servers who are trustworthy to serve as key employees for shifts, sometimes once or twice a week. Those key employees are not exempt. The majority of their work is performed on the floor as a server. The servers are non-exempt positions. When a small amount of time is spent in a managerial role, that is not enough to make that person exempt, even exempt for their time as a manager. So the entirety of their employment is considered non-exempt, even though from time to time they may perform some roles that could be considered exempt. And what happens when you have a hybrid employee is that they must be paid during their time serving as a manager, when they're not on the floor receiving tips, they must be paid at least the minimum wage cash in pocket for those hours. For the administrative exemption, it's a little similar, but there are some important nuances. The primary duty for the employee must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And their primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. So when I talked a little bit earlier about the restaurant I worked in that had an in-house accountant, that person would very likely be subject to the administrative exemption and be exempt from the overtime requirements of the FLSA because they were doing office work. They weren't serving tables. They weren't making any, they weren't working in the restaurant, so to speak. They were always back office staff. And they had to use their discretion and independent judgment to ensure the proper taxes were paid, things like that. You would also likely get an exemption under the administrative exemption for someone like a human resources manager. But again, kitchen managers, front of house managers, back of house managers, they're not going to be qualified under the administrative exemption. You'd have to rely on the executive exemption for those individuals. So the second factor to talk about with the exemption and non-exemption determination is the salary basis test. And when I talked a little bit earlier about I pay my manager, the myth that I pay my manager a salary, therefore they are exempt. In theory, that can be true, but in reality, being paid on the salary basis test is a very specific test. And what that salary basis test means is that an employee has to be paid the same amount of money for every week of work, or less frequently, so they can be paid every 2 weeks, sometimes every month, depending on the state you're working in. And that amount cannot be subject to reduction based on variations in quality or quantity of work. So if they're paid on a salary basis and they only work 20 hours in a week, they have to receive the same amount of money whether they worked 20 hours that week or 40 hours or 50 hours. There are a couple of exceptions. You do not have to pay a salaried employee who performs no work in a week. So essentially what that means is that you're not required to pay an employee. You're not required to give someone vacation. You're not required to pay someone when they're not working. And you also do not have to pay a salaried employee who misses 1 or more full days for personal reasons other than sickness or disability. There are some caveats to this. I don't want you to take this as the gospel, but generally speaking, if an employee calls in to take personal time and says, you know, my car broke down, I can't come in today, you do not have to pay an exempt employee for that type of circumstance. Again, the salary must be no less than $684 per week. That's the federal standard, which means that everywhere in the country, if the company is subject to the FLSA, talk about that more in a few minutes, then you have to, no matter what, hit that $684 per week standard. Some states have a different salary basis threshold requirement. It's usually a little higher, but it theoretically could be a little lower in some states. If that person is employed in that state, they must hit the higher of the 2 salary basis requirements. If that person is paid a salary, but the employee is non-exempt, and this comes up quite a bit in the restaurant industry, the hourly rate is their salary divided by 40 for their regular rate, and then they have to be paid 1.5 times that for overtime. So let's say that your restaurant decides to pay non-exempt workers, let's say a server or a kitchen staff, a salary. They're going to get a flat amount every single week, no matter how many hours under 40 they work. If they work overtime, if they work over 40 hours in that week, you can't rely on their salary to decide not to pay them the overtime premium. Their salary, let's say their salary is $800 a week, so that's $20 an hour. They're paid $20 an hour. If they work 40 hours, they're going to get their $800. But if they work 50 hours, those extra 10 hours they worked have to be paid at time and a half or $30 an hour, even though that individual is typically a salaried employee. This is where things start to get very confusing and difficult, and this is where you have to be very careful with the way you pay your employees to ensure you're not violating the FLSA. So, sorry, I think I've clicked on the wrong button. Maybe not. In any event, going back to the key takeaways, my myth number 1 was if I pay my employees a fixed salary, I don't have to pay them for overtime. The real answer is that salary is just one factor in determining whether you have to pay overtime. Employees must be exempt under the job duties test as well, and if they fail either the job duties test or the salary basis test, that individual is not an exempt employee, and they must be paid at a rate of 1.5 times their regular hourly rate for any overtime hours they accrue. And going back to myth number 2, managers never receive overtime. Managers actually must receive overtime if they do not meet both the job duties test and the salary basis test, and that decision has to be made on a case-by-case basis. So let's talk a little bit about the minimum wage. The federal minimum wage hasn't changed in quite a long time. It's $7.25 an hour. There are different state and local minimum wages. Currently, the lowest minimum wage in the country is $5.15. That applies in Georgia or Wyoming. But if you are a restaurateur in Georgia or Wyoming and you meet the requirements of the FLSA, you don't get to rely on the $5.15 an hour minimum wage. You have to follow the federal minimum wage. Minimum wages go as high as $15.20 an hour. That's the current District of Columbia minimum wage. You must be, if you qualify under the FLSA, you must meet both the FLSA minimum wage and the state minimum wage that applies to you. So you can't pick and choose, you have to meet both of them. So in Washington, D.C., even though there's a federal minimum wage of $7.25 an hour, you have to pay your employees a total of $15.20 an hour. So I've said a couple times, whether your company is subject to the FLSA. What I mean by that, and I'm simplifying the test a little bit, but this is the general test that you have to follow. The company must have $500,000 or more in annual sales. Now that's not profits, it is sales. So if you are essentially selling generating at least about $10,000 a week in revenues, you're going to hit that 500,000 or more in annual sales per year, and you're going to be subject to the FLSA. The other requirement is that the employees of the restaurant or company must be engaged in interstate commerce. Now, this is a very complicated way of saying that they deal with wires like credit card transactions, or that food, beverage, or utensils, furniture, or other aspects of the business have crossed state lines in some way, shape, or form. If you are in the Mid-Atlantic region, if you're in Washington, D.C. or Virginia, and you're selling seafood of any kind, it's probably coming from outside of the state, usually Maryland, maybe North Carolina. There are some seafood distributors in Virginia, obviously. But if you are a landlocked state, almost assuredly the Fair Labor Standards Act is going to apply to you because your products and services are crossing interstate lines. And at any time that the credit card is involved, you're crossing interstate lines there as well. So on top of the minimum wage, you have to pay overtime wages where they apply. And both the FLSA and every state law in the country require overtime payments of 1.5 times or sometimes more of the regular hourly rate for hours worked in excess of 40 in a given week. Like I said, some state laws go further. If you're in California, you have a very complex overtime requirement. A person may work less than 40 hours in a work week, but if you work more than 8 hours in a single day, they have to be paid overtime for any hours in excess of 8 in a day. Again, they've got to pay 1.5 times anytime they exceed 40 in a work week. You're also paying 1.5 times for more than if an employee is working more than 6 consecutive days in a single work week. You're paying 2 times the wage, essentially super overtime, for any hours over 12 worked in a single day. You're also paying super overtime if they work over 8 hours on a 7th consecutive day. Again, you must meet both the FLSA overtime wage and the state overtime wage that applies to you. And if the FLSA you are subject to the FLSA, you're going to have to meet the overtime requirements of your state, of the federal government, and if you're in a county that implements a minimum wage requirement or an overtime wage requirement, you must meet those as well. All right, some of you are probably here because this is a very hot button issue, the tip credit. Myth number 3, something I hear a lot: if I don't take the tip credit, I can retain my employees' tips. We're going to talk about that at the end of this slide, but the answer to that is no. The tip credit generally allows restaurants to credit a portion of an employee's tips toward the minimum wage. In order to qualify for the tip credit and allow the restaurant to take that credit against the payment of the minimum wage, the employee must regularly receive tips as part of their regular wages. That's generally considered to be more than $30 in tips per month. And the tip credit can only apply to hours of work that produce tips or directly support tip producing work. There are some new FLSA changes coming in at this month in 3 weeks. And generally speaking, the rules that apply to what is tipped and what is not tipped work are changing a bit. However, you can generally assume that work that produces tips is going to be direct interaction with customers, and work that is directly supporting tip producing work would be preparing the restaurant for the most part for service or cleaning up the restaurant in some respects after service is complete. It might also be restocking. So let's say you have a coffee station, making sure that your coffee is brewed, that your refrigerator has appropriate milk and cream in it, things like that. There's also a category, which we'll talk about in a few slides, that is non-tipped work. That is going to be things like cleaning the bathrooms, picking up trash in the parking lot, things like that. Those are, you're not eligible to take the tip credit for that kind of work. But the main thing to take out of this is, regardless of whether you take the tip credit or you avoid the tip credit because you pay your employees the minimum wage, the employer cannot retain any portion of the employee's tips. There are a couple of cases in various portions of the country, usually appellate cases, that have deviated from that general rule in some respects. They have implied that it is possible to, so long as you pay your employees at least the minimum wage, that the tips do not have to be paid. This is generally frowned upon by the Department of Labor. The Department of Labor has fought to make sure that all tips stay with the employees that earn them. And so generally speaking, you should consider in most parts of the country that an employer cannot retain any part of an employee's tips. So when taking the tip credit, a few things to remember. Tips must equal or exceed the difference between the cash wage and the minimum wage. The employer must pay the difference. Currently, the federal tipped minimum wage is $2.13. It hasn't changed in quite a while, which means, considering that the federal minimum wage is $7.25, that an employer can take a $5.12 per hour tip credit for hours up to 40 in a given week. That means that the restaurant is responsible for paying the first $2.13 of every hour, and then the tip credit can make up the difference and pay the remaining $5.12 per hour. However, if at the end of the day, subject to a few issues that we're going to talk about, if the employee has not received $7.25 for the day, let's say it's a very snowy day and there just weren't very many customers, the restaurant needs to make up the difference to ensure that those individuals have received the minimum wage for their work. For overtime, the tip credit stays at $5.12, which means let's say there's someone who works 50 hours, the first 40 hours would be the restaurant is responsible to pay $2.13 an hour. For those last 10 hours, what they've worked overtime, the restaurant is responsible for paying the first $5.76 per hour that employee worked. And the way we calculate that is, when you are a minimum wage employee, you make $7.25 an hour. Your overtime rate is about $10.38 an hour. And when you reduce the tip credit from the total amount of the overtime wage that is required to be paid, sorry, I think it's actually higher than that. $10.88, something along those lines, the restaurant is left to pay the difference, $5.76. In DC, for example, the tipped minimum wage is $5.05 an hour, which means that the employer can take a $10.15 tip credit for regular wages. For overtime, the employer can still only take that $10.15 tip credit, which means the restaurant is responsible for $12.65 for any overtime hours worked. But again, if the employee's tips don't make up the difference to get to the minimum wage or the adjusted minimum wage or the overtime wage, then the restaurant must make up the difference. Some states flat out do not allow for the restaurant to take the tip credit. Those states are up on the board: Alaska, California, Minnesota, Montana, Nevada, Oregon, and Washington. So you're seeing a lot of states on the West Coast, plus Minnesota. DC is likely to be the next jurisdiction to move toward abolition of the tip credit. I don't want to speculate, but it does seem like it is as close to a foregone conclusion that DC will abolish the tip credit sometime in the next year. Perhaps it could be extended a little bit longer. If you are a big fan of the tip credit, and I understand that most restaurants are under the circumstances, get out there, advocate with your city council members, talk to the Restaurant Association of Metropolitan Washington, talk to your colleagues and to the other restaurants in your neighborhood. Make sure they're reaching out to the appropriate people to advocate as much as you can for the tip credit. But as it stands right now, DC is likely to lose the tip credit at some point in the near future. Under those circumstances, the minimum wage will be required to be paid to every employee. So for instance, right now, the DC minimum wage of $15.20 would need to be paid to every server, every bartender, every busser in a DC establishment once that change in the law is eventually passed. Currently, you can use the tip credit, perhaps no more sometime soon. And then some states allow for a tip credit, but they require a higher direct or cash minimum wage. I'm putting it in as a best practice here. It's important for you to be very careful about the way you use the tip credit and the amounts that you're paying as part of the tip credit, because they vary from state to state, the rates vary from state to state, and the implementing rules vary from state to state. Make sure you are very comfortable with the rules applicable to your establishment. If you are a chain or part of a restaurant group and you have restaurants in, let's say, 10 states, you may very well have 10 different laws that you have to follow in addition to the Fair Labor Standards Act. Pay very close attention to where you employ people. Make sure you're being compliant with the FLSA and its implementing regulations in every location where you do business. So I mentioned a little bit earlier that there are some new rules coming for 2022. Those go into effect in 3 weeks on December 28th. A couple of the ones I wanted to highlight, there's more than this, but these are the important ones. If an employer pays all of its workers the full minimum wage, it can establish a non-traditional tip pool which could be shared with back-of-the-house employees. Currently, if the person earning the tips, typically servers and bartenders, they cannot be made to share their tips with back-of-house employees such as kitchen staff or dishwashers. There is an exception for food runners who are operating on the front of house. As of December 28th, you might want to give it a couple of weeks just to make sure there are no legal challenges to it. There would be a permissible tip pool where back-of-house employees could share once those new rules go into effect. The next change that's coming for 2022 are what I call the side work rules. That's my term of art, not the actual statute's term of art. And we touched on this a little bit earlier. Work for restaurant employees can be categorized as one of three things: tip producing work, directly supporting work, or non-tipped work. That tip producing work, that waiting of tables, serving customers, that may be paid at the tip credit wage until, of course, the tip credit is abolished in your area. Directly supporting work may be paid at the tip credit wage, but it cannot be more than 30 continuous minutes of time for that employee or more than 20% of their work week hours. If you are in, I'll give you an example. I worked in a restaurant in the early 2000s, and we were expected to show up an hour early so that we could prepare the restaurant for the shift. Sometimes that meant polishing glassware or rolling silverware. All of those things are directly supporting work. Can't serve someone silverware if the silverware hasn't been washed and rolled. I'm sorry, can't serve someone food without silverware. And candidly, those tasks typically did not take more than 30 minutes, but sometimes they could have, depending on what was going on. Managers should be very careful to schedule people so that the pre-shift side work that is related to serving customers does not take longer than 30 minutes. This might seem nitpicky, but currently there is no plan to give the benefit of the doubt to restaurants that might be using their employee time for 35 minutes, 36 minutes. There is a possibility that that will be implemented by the courts, or that the courts will construe those extra minutes to be de minimis. But for now, you want to make sure that you're paying attention very closely to the work that's being done and staffing enough people to get the restaurant set up within the allotted time. So the other thing that can't happen is that the side work rules, or the side work that is required, the directly supporting work, exceeds 20% of the work week hours. So if you are a smaller restaurant, maybe only open for 2 hours at lunch and 5 hours at dinner, you're talking about a 7-hour work day. Maybe they work 5 days a week. If they do more than 7 hours of side work before and after shifts over the course of the week, you've exceeded the 20% rule. So managers, again, should be very cognizant of the amount of side work and what's called directly supporting work that individual employees are performing. Now for the non-tipped work. This work is considered work that does not directly benefit the tip producing work. So it's generally not made for a customer who's leaving a tip, for instance, or who would be expected to potentially leave a tip. Again, this would be cleaning of bathrooms, stacking boxes or storage, delivering catering boxes or catering meals, or assembling catering boxes. If those employees are not going to be tipped for their work for the catering boxes, for instance, say the restaurant uses a catering service to deliver the work, those people might be paid for the delivery, but the restaurant doesn't receive a tip for it. That would be considered non-tipped work, very likely. I'm going to be a little wishy-washy here because I imagine that some courts would say that was directly supporting work, but a number of courts are going to say that's non-tipped work. If you are expecting your employees to do that kind of work, they must be paid at the minimum wage or higher. There are some other considerations you have to take into account when calculating how you have to pay individuals, and that's particularly in the restaurant industry, split shifts. A split shift is where an employee is expected to work hours during a day that are not consecutive. So if you're working a lunch dinner double, you might come in from, say, 11 a.m. to 1:30 p.m. Then you're cut early because you're coming back for dinner, and then you come back at 4:30 p.m. and you stay until 10. It's a pretty standard shift, happens frequently in big cities where there's not a lot of business done between the hours of about 2:30 and 4:30. If the break that the employee receives is longer than 1 hour between shifts, they're working a split shift. There are no federal regulations, and there are many states that don't have regulations on split shifts. but there are a number of states that impose specific rules for employees working split shifts. If the employee is required to remain on the premises, in other words, they're, quote, on call, maybe they're sitting in the back, they're allowed to take a break, they can have some food, but they are not allowed to leave the premises, they generally must be paid for all of those hours, including the break, even if they're sitting in the back eating. If, however, they are free to leave the restaurant and to go about their business, run errands, get food on their own, this will vary state to state, but many states require an employer to pay some amount on top of the hours worked for a split shift. In DC, that's 1 hour at minimum wage for every split shift with a break of longer than 1 hour. So if, and this is a very common point of contention for restaurants being sued in DC in particular, if they didn't pay the split shift, essentially 1 hour of minimum wage bonus during the split shift, then they are subject to an FLSA violation. Other states have meal and rest break requirements. This is a typical mandatory amount of break time provided for every shift. In states like California and some other states on the West Coast, every employee, with some exceptions, is entitled to a 30-minute break for every consecutive 5-hour shift, plus an additional 30 minutes if their shift goes to 10 hours or longer. Currently, DC does not have meal and rest break requirements. The failure to provide the mandatory meal and rest breaks result in additional penalties. In California, there's required pay of 1 hour of work for every missed break, for instance. So if a person is working a 12-hour day, 3 days a week, for instance, maybe 3 doubles and they happen to be running long, if they're not getting their missed breaks, which would be 2 required for every shift, then you need to pay them an extra 2 hours per day for missing the meal and rest breaks. So I'm getting a question from the group. In DC, if the employee is told to take a 45-minute break and comes back in 1 hour and 15 minutes, do we still need to pay a split shift payment? So technically, if this is a one-off, no. But here's the problem. You would be paying them for the 45 minutes. The break that is less than an hour is essentially telling the employee that they don't have the ability to freely roam. They might be able to go down the street, but if it takes them longer than 10 or 15 minutes to walk to the place where they're going, or they have to go get a car to drive somewhere, a break of 45 minutes is really not going to be a break that triggers a split shift calculation. And if they are expected to come back, you're likely going to have to pay them for that time. If they come back late, no, they're not triggering the split shift payment. Misconduct by the employee cannot trigger a new requirement under the FLSA. Now, I do want to caveat that by saying, if you're telling, I'll get to that in a second. What I am going to say though is, on a split shift, if they're allowed to leave for 45 minutes, they come back after an hour and 15 or an hour and 30. No, but that is a performance problem that you need to address separately. If you let it go, and if you let the person take an hour and 15 minutes 4 times a week, and you don't reprimand them or write them up for taking that hour and 15, that in a subsequent lawsuit, that could be considered waiver or acceptance of the hour and 15-minute break, and that could then trigger a split shift payment. If it's happening frequently, you should err on the side of caution and pay the split shift payment. But generally speaking, if they're not violating, if they're violating your instructions, then no, it does not trigger a new payment under the FLSA. The exception to that is if you tell someone that they are not allowed to work more than 40 hours in a week and that overtime is not permitted, and that individual works their schedule, and because of circumstances, whether within their control or outside their control, they work more than 40 hours, they are required to be paid for those hours. If they turn in a timesheet at the end of the week that says they worked 43, you must pay them for those 43 hours. You cannot dock their pay for 3 hours because you have an ongoing rule that overtime pay will not be paid. Now, if someone has forgotten to clock out, and at the end of the night, when the manager batches all of the computers and clocks everyone out of the POS system, and there's reason to believe, a legitimate reason to believe that person didn't work the full 43 hours, you can make the adjustment. But you need to document that adjustment overall. So that's an exception. The general rule is that if an employee misbehaves and it causes an FLSA violation, that one-off violation is not going to get you in trouble. However, if you are aware that an employee did the work and isn't going to be paid for it, you need to make sure that they are properly compensated. Talking a little bit about another important factor in lawsuits that come up under the FLSA, and I am going to have to speed up a little, I'm sorry. Myth number 4, the restaurant pay is common knowledge and everyone in the industry knows how they will be paid. What I mean by this is, if you know anyone in the restaurant industry, at some point or another, you've been told, I don't make much money in the hourly wage, I make all my money in tips. Yes, that is pretty common knowledge, but it's not sufficient under the Fair Labor Standards Act. The FLSA and almost all state laws require employers to provide notice of the manner in which the employees will be paid at the start of their work. The employer loses the tip credit if it fails to provide that notice, and it is not sufficient to make the assumption that an employee knows how the tip practice works. I had a case last year, an FLSA case, where I took a deposition of an employee who, and I said, I asked, you understood how you were to be paid at the restaurant? She said yes, and then I asked her to explain it, and she had no idea. She thought she was paid a flat hourly rate and that her tips were split amongst a number of people, and that she didn't know that she was receiving tips. Whether or not that's true, we will never know. The case ultimately settled, and she wasn't testing that theory in front of a jury. But it is not enough to assume that an employee understands how they're going to be paid, particularly if they've never had a job in a restaurant before. So best practice here, you want to provide a written manual or have a benefits and rights page that an employee signs at the time of hire, and that signed original copy is placed in their personnel file, and they should be given a copy of it, but you want to maintain the original. Record keeping requirements, equally as important as the notice requirement. Employers are required to keep records under the FLSA and each of the state wage and hour statutes. You need to keep track of the hours worked by each employee. You need to be accurate. It's very easy to say this person worked 8 hours in a day, but did they really? Or did they work 8 hours and 15 minutes? The difference between 8 hours and 8 hours and 15 minutes may not seem like a lot, but if it's happening on a frequent basis, it turns into a very, very significant claim. We're going to talk about what the penalties for a violation of the FLSA are in a couple minutes. You need to keep track of the hourly rate those individuals were paid. You need to keep track of the tips that individual received, the taxes that were paid for that person, and any deductions from pay. Another best practice for you, save all of the source documents either in hard copy or electronic form or both for a minimum of 4 years. The reason I say 4 years, and I put an asterisk there for a reason, is that the statute of limitations under the Fair Labor Standards Act is either 2 years or 3 years, depending on the circumstances. In Washington, D.C., it's also a 3-year statute of limitations. In Maryland, it's a 3-year statute of limitations. But in some states, New York, for instance, the statute of limitations varies between anywhere from 4 to 6 years. If the statute of limitations for an unpaid wage claim in your state or location is, let's say, 3 years, you want to hold those records and make sure they're accessible for an extra year on top of that. If your statute of limitations is 6 years, you want to keep them for 7. The reason you want to make sure that you keep all of these records on file is because they will be your best defense moving forward under the FLSA. Myth number 5, and I get some version of this on a daily basis across every single industry in which I represent companies. I operate in an at-will employment state and I can fire someone for any reason. That is actually a generally true statement of the law, but there are exceptions. The FLSA has a specific anti-retaliation provision, which states that for any person, it is unlawful for any person to be discharged or in any other manner discriminated against because an employee has filed any complaint or instituted or caused to be instituted any proceeding under or related to the FLSA, or they've testified, or they're about to testify in such a proceeding, or they've served or are about to serve on an industry committee. Most courts that have considered the issue have applied the anti-retaliation provision to internal reports, to management or ownership. That could be complaints about wage payment practices. That could be allegations that the manager is stealing from the tip pool. I had that case a little more than a decade ago. There could be complaints about the participants in the tip pool, that maybe back of house staff are getting tips. And this applies, keep in mind, when the statement, the allegation, the complaint is incorrect as well. Let's say that an employee comes to you and says, I'm really upset because the line cooks are getting some of the tip pool. You certainly can tell that person that line cooks are not getting any part of the tip pool. But you also cannot terminate that person for causing problems in the future or for being what we call a serial complainer. Liability and penalties under the Fair Labor Standards Act, generally speaking, you would be responsible for not only the unpaid wages, but a liquidated damages amount equal to the unpaid wages, plus attorney's fees and costs on top of that. I like to tell people that a $100 mistake can turn into a $100,000 judgment. I don't like having to say it, but that is the reality of it. In order to avoid the liquidated damages and in some states the attorney's fees and costs, the restaurant must have acted in good faith and must have had a reasonable belief that it was acting appropriately under the circumstances. A violation of the statute in your state can have even greater significant penalties. In DC, the employee is entitled to up to 4 times the amount of the unpaid wage, plus attorney's fees and costs. Other states have similar numbers, like Maryland's is 3 times. So let's talk a little bit about audits and investigations. And again, sorry, now I'm going to have to start racing through the rest of my slides. The Department of Labor has independent authority to investigate wage and hour violations. That includes before they've filed a lawsuit and after. They can impose requirements that companies pay back wages, penalties, and they will issue a public press release. So it's very important that you are following the FLSA to avoid regulatory investigations. State departments of labor and attorneys general have the authority to investigate as well. And in some states like California, a failure to pay wages can result in what's a consumer protection violation, which can lead to up to treble damages and attorney's fees as well. The Fair Labor Standards Act and state wage payment and collection laws can result in what's called class or collective actions. This means that a single employee can bring a lawsuit on behalf of themselves and all others similarly situated. The similarly situated test is pretty easy to meet. So for instance, if a server says that they were not paid correctly or they were subject to an improper tip pool, they can bring that suit on behalf of themselves and all of the servers employed by the employer. These suits can result in a written notice being sent to all of the employees, It sort of drums up bad will against the company, but it also results in a lot of people jumping on a bandwagon and adding to the ultimate damages that can be recovered. And again, if it's a DC wage and hour violation, we're talking about 4 times the amount of unpaid wages. This type of litigation is very complicated and expensive, and so it's a huge risk for violating the FLSA. So how to minimize your risk? The first and most important thing is to maintain a very robust paper trail throughout all of the steps that we've talked about today. You want to review your classifications and document how you've reviewed them and how you've analyzed whether people are exempt or non-exempt under both the job duties and the salary basis test. You want to periodically conduct audits of your classifications and determine whether the job duties that the person is actually performing are still exempt or non-exempt, as opposed to what they were doing at the beginning. You want to create a cheat sheet for your wage payment requirements and post in your back office or wherever your manager or owner does payroll. You want to make sure that if they have questions that they're thinking, let me look for that answer, not let me guess and make sure, and because this seems right, because often the FLSA things seem right and they're actually not quite right. You want to train your managers, supervisors, and schedulers to ensure that they are drafting a compliant schedule to make sure that you are cognizant of split shift payments, regular and overtime hours, appropriate meal and rest breaks, and the proper distribution of whether they're doing the side work rules. You also want to ensure a robust document retention policy, making sure that when a manager, for instance, is calculating the distribution of the tip pool, that their piece of paper or their chart that shows how it's being distributed is being saved right alongside the amount that was actually paid out. You want to draft a comprehensive employee manual and require employees to sign and acknowledge it. This is something that I often recommend that a lawyer do for you. My firm has put together a number of manuals over the years, and what we end up doing is taking a restaurant's manual and basically rewriting it, because we want to make sure that the FLSA is very clearly set forth in the manual so that people understand exactly what they're signing up for when they start your job. This is going to help prevent lawsuits in the future. You're going to want to consider adding operations questions to any employment examinations. When I was a server, I used to take an exam about menu items, ingredients, things like that. You can consider adding operations questions like, how is the tip pool organized? How am I going to be paid? Do I understand my job duties? When they submit that, they're giving themselves, and if they haven't answered it correctly, you can have training with them to follow up. You want to identify problem areas early and fix them right away. The longer a problem goes on, the more likely it is to result in a lawsuit. You want to conduct internal audits of wage payment practices and tip procedures frequently. You want to take employee complaints and demand letters very seriously, investigate and document, and here's my shameless plug, develop a relationship with a labor and employment and litigation counsel, because these days, if you run a restaurant, you're probably going to get a demand letter or a lawsuit at some point alleging a wage and hour violation. I'm going to go very, very fast and give you the high level here. Keep in mind, we do make these slides available, or the webinar rather, available online through YouTube. You will get an email that follows up to this webinar with a blog that I wrote a few months ago, and I'm going to continue to write blogs that provide really similar information to this on our website. So please take a look at PilieroMazza.com and look for my profile. You'll find my blogs. So in the unlikely event or potentially likely event that you get an investigation, claim, or lawsuit, you want to get a lawyer involved right away. Regulatory in-person investigations are rare, but they do happen more often on the state level. Sometimes an investigator will show up at the restaurant at the start or in the middle of a shift, and they will request access to the premises or to interview employees. If they are coming in the middle of a shift, you state, we're in the middle of a shift. I don't want to disrupt them from their work. Please coordinate any inspection with my attorney. give them the information for your attorney. Usually they will agree. The time that they will not agree is if they think that a criminal matter has occurred, or if they have any number of other issues that they think evidence is going to be destroyed. If that's the case, get the lawyer on the phone right away and have them come down to the restaurant and handle the communications with the investigator. You want to cease all routine document destruction and compile all relevant documents quickly. And other than accepting service of the documents or obtaining contact information, do not speak to the investigator or any attorney without counsel present or involved. The number of times that I have had to walk back things that my clients have said because they didn't understand a question or they thought they were being investigated for something else is really too many to count. So you want to be very careful. This isn't a criminal matter. You don't have the right to remain silent, but you certainly want to take that good advice even in the civil context. Last thing I want to say, do not ignore complaints that come in from employees. Employees can be your biggest advocates. They can talk about how great your restaurant is, but they can also cause the most problems. You want a great relationship with your employees so that they will come to you when they think there's a problem instead of going to a lawyer first. So when they come and complain about something, take them very seriously. Again, retaliation is impermissible, so do not take adverse employment action, either demoting or changing their shifts or terminating them. What constitutes a bona fide claim? You need to look into the underlying facts that they're alleging and actually investigate them. It's not enough for you to say, oh, I know that manager very well. He's not stealing from the tip pool. You've got to investigate it. Take that complaint seriously, because you might actually find out that that manager that you trust is skimming off the top a little bit. The serial complainer, it's very easy to say that someone is a distraction for the rest of the employees because all they do is complain, but those people are very likely to be the people that make ultimately the lawsuit or the complaint to the investigator. You want to make sure that you're taking their complaint seriously too. It might take a little more time out of your week, but it will benefit you in the long run. And then when I mentioned before about the paper trail, you got to document not only the background, the wages you're paying, but the investigation as well. This slide basically says the exact same thing I just said. So if there are no further questions, you have about 30 seconds to plug them into the question box. I'll try and get to them if I can. It's been a pleasure to talk with you today. I'm sorry that I went a little bit over. If you have any follow-up questions or like to talk to me further about a specific issue, please reach out to me. My contact information is on the screen, and you can also find my contact information, particularly my email, on the PilieroMazza website at PilieroMazza.com. For those of you who are still listening, we still have a few of you. Enjoy the rest of your week, and I hope to see you again on a future webinar. Thanks so much.